All right, y'all. So this lawsuit, the plaintiff is Christine or Kristen. We're going to say Christine. I hope that's how you say her name. Davis. So the plaintiff is the person that is actually suing someone. And then the defendants are the people who are being sued. They're defending whatever they're being sued for, right? So they're the defendants. So Christine Davis is the plaintiff, and then the defendants is a lot of them. The Walt Disney Company, American Broadcasting Company, which is ABC, Non-Squitter Productions, Blue Park Productions, Siobhan Sullivan Wright, Sharice Parks, and Quinton Brunson. So when you file a lawsuit, you want to bring it against all the people that you can, because if you don't include certain people, the case might get thrown out because you might not be suing the right person. So you want to try to sue everybody to make sure you get the right person, okay? And to make sure you get them coins. So that is what is going on here. She is suing everybody that needs to be sued, or everybody that she thinks needs to be sued. So then it's the complaint. Okay, we're not going to go over that part. Introduction. So some parts we're going to skip because, like I said, lawsuits can be boring and we want to keep it spicy. So the introduction. This is a civil action seeking actual and statutory damages for copyright infringement arising under the copyright laws of the United States, the Copyright Act. Plaintiff is the sole owner of work copyrighted pursuant to the Copyright Act under registration number, and she provides the number that her copyright is registered under. The work pertains to plaintiff's original scripted television series, This School Year. So basically, she's in this lawsuit, she's saying that Abbott Elementary is a copycat version of her script, This School Year. Her script to a show called This School Year, I'm sorry. Defendants directed, produced, advertised, sold, and streamed the Abbott Elementary television series that premiered in December 2021 and defended ABC Television Network and Hulu Premium television channel and streaming services. Abbott Elementary is a veritable knockoff of plaintiff's proposed television series This School Year. They called it a knockoff, or she called it a knockoff. When somebody say a knockoff, I think low budget, low brand. So she is upset. And I would be too if I felt like someone copied off of my hard worked for creative work, okay? So she calling Abbott a knockoff, which is crazy because if she calling it a knockoff and it got 7 Emmys, I wonder what hers was like, you know? Okay. Without plaintiff's permission, license, authority, or consent, defendants knowingly and illegally use plaintiff's works to create the Abbott Elementary television series. So I want you guys to pay attention to the wording in this lawsuit because every word is placed there for a reason. And what I mean by that is when you bring up a lawsuit, when you're suing someone, there's certain elements that needs to be met by law, and there's certain things that you need to say to make the courts know that you are hitting those certain elements and those certain things. I hope that makes sense. But so you want to strategically pick out your wording when you're filing a lawsuit. And I feel like that's what they did here. So one of the things is when it's copyright infringement, you're saying they copied it without your permission. And so that's why they say that in here. And then they're saying it's without my permission. We didn't give her a license. We didn't give her no type of authority to do this. So that's why that sentence is very important, because they need to know we did not give them permission and they knowingly did it. So it wasn't an accident. They didn't do it by accident, like accidentally copy my work. No, they knew what they were doing and they copied it. That's why they put that knowingly. So that is very important as well. Defendants Abbott Elementary television series and the content protected by plaintiffs' registered copyrights are striking and substantially similar. So there they go again, trying to make sure they're pointing out the infringement part of it. They got to hit those elements, okay? So striking and substantially similar. Defendants neither sought nor received permission from plaintiff to utilize her This School Year work as the basis for Abbott Elementary series. Moreover, defendants have made millions in profit from their knowing infringement plaintiff's copyright of, I guess it's a typo. So let me read that again. Moreover, defendants have made millions in profits from their knowing infringement of plaintiff's copyrighted work. So she's saying they made the coin off of her work. As a result of defendant's infringement of plaintiff's copyrighted works, plaintiff seeks damages, including inter alia and accounting of profits by defendants, damages and lost profits of plaintiff, costs and attorney's fees, or at plaintiff's election, statutory damages. Plaintiff also seeks equitable relief, including preliminary and permanent injunctive relief and impoundment and destruction of the infringing articles to prevent further violations of plaintiff's rights under the Copyright Act of 1976. Furthermore, because defendants willfully and deliberately infringed upon plaintiff's copyrighted works, plaintiff seeks an award of attorney's fees and costs pursuant to, and then they put the section of that law. Okay, so what this paragraph is saying is we want you to pay us money. We also want you to stop doing something. So when they ask for equitable relief, including preliminary and permanent injunctive relief, they're saying we want you to make them stop doing something, stop infringing my copyrighted work. So they want money, they want the defendants to stop copying them, and they want an impoundment and destruction of the infringing articles. They basically want to take that stuff and destroy it. So all of those seasons, I don't know how many seasons, I don't know if it's 1 season, 2 seasons, I don't know. But whatever seasons of Abbott Elementary, all of that, they want that stuff destroyed. So that's big because this Abbott Elementary is getting 7 Emmys. So they're coming, they're upset. And if this is true, then I don't blame them. You got to protect what's yours, right? If this is true. Okay. All right, this next page wasn't important. I kind of briefly went through it because I was like, I'm going to cross off stuff that's not as important so this video don't be an hour long. And so it's not boring. Okay. So facts. So that was introduction just to kind of give us what's going on, what they're trying to do. Now we're talking about the facts. Ms. Davis created and owns the copyrighted work. So this is her going into, I created this, I own this, this is what happened. Plaintiff is and for many years has been an aspiring writer, actress, and performer in NYC. Plaintiff is also a licensed New York City school teacher. She lives and works in New York City, New York. Plaintiff created this school year, TSY, so that's what they're going to call it, TSY throughout, in 2018 and registered it on March 6, 2020 with the United States Copyright Office under copyright registration number. It gives a number. Plaintiff's copyrighted works are registered as a work of the performing arts. Plaintiff also registered TSY with the Writers Guild of America in 2021 under registration ID number, gives the number, WGA registration ID summaries attached here too as Exhibit 1. That's just, she just attached her proof. Exhibits are proof of what she's saying. TSY is a television comedy set in New York City, PS, public school, 311. The principal hires filmmakers to film a documentary of the school, leading to TSY's mockumentary style. There is a new principal who is convinced everything is going well, that the school is well controlled, and that the teachers and students will adhere to her agenda. However, the teachers, staff, and students have their own agenda, especially Ms. Davis, the main character. Ms. Davis is a young, idealistic teacher hoping to get tenure, but also trying to convince everyone that school needs to be reformed, that the school needs to be reformed. So those are the facts, or part of the facts. Next, it says defendants had access to plaintiff's copyrighted work. So remember I said you have to be able to prove the law. You have to prove the elements to get a copyright infringement case. So the first thing she said is that she owns the copyrights. That's one thing she have to prove. She have to prove that she was the owner. The next thing that she have to prove is that they had access to her work, because if they didn't have access to her work, how could they see her work to copy it, right? So that's what she's going to talk about next. In mid-June through July of 2020, the plaintiff contacted Siobhan Sullivan Wright and Sharice Parks at Blue Park Productions in Los Angeles, California. Remember those names? Those are the defendants. The plaintiff had been made aware of Blue Park Productions by a family friend who was acquainted with Blue Park Productions. Over the course of the next month, the plaintiff and Blue Park Productions had at least 3 meetings regarding plaintiff's script for the school year. On June 15, 2020, Defendant Wright sent non-disclosure agreement, NDA, to the plaintiff for signature. So the defendant sent Christine Davis an NDA. And an NDA is a non-disclosure agreement, basically saying you're not going to tell somebody something, right? So we don't know exactly what was in this NDA. I haven't read it. I haven't looked it up. I don't know. I don't even know if it was included in the lawsuit because I didn't look. But they sent her an NDA, right? So she signed the NDA. On June 15, 2020, plaintiff signed and returned the NDA to Defendant Wright. So Christine, the person that's suing, she signed it. She sent it back to him. On June 15, 2020, under cover of separate email, plaintiff emailed a copy of her script for the TSY and the Story Bible to Defendant Wright. So this is her proving her access, and apparently she got it in writing because it was an email. So she emailed them her script, so they did have access to this script. On June 16, 2020, Defendant Wright acknowledged receipt of the script via email. So now the defendant, the person she's suing, said, we got the script. On June 21st, 2020, Defendant Wright wrote to plaintiff telling her that they needed more time to read the script in depth. On June 30th, 2020, plaintiff emailed defendants with updates to the script and story ideas for episodes. On July 12, 2020, Defendant Wright emailed the plaintiff to set a meeting for that Friday. The meeting was held on July 12, 2020 and conducted via Zoom. Defendants Wright and Park reiterated their excitement regarding plaintiff's script and story idea for TSY. Defendants Wright and Park repeatedly expressed that they had connections at Hulu and were aware that Hulu and ABC were looking for Black female-led comedies. So Hulu and ABC were looking for Black female-led comedies. And from my understanding, Abbott Elementary is a Black female-led comedy. Defendants Wright and Park gave plaintiff notes on the script and proposed that they would meet again. Upon information and belief, defendants Wright, Parks, and Blue Park Productions took plaintiff's script and storybook and presented it to Hulu. Remember, Hulu is where Abbott Elementary comes on. Okay, this is good, y'all. In September, Non-Squitter Productions and ABC Television commenced production on Abbott Elementary, a new Black female-led comedy with substantial similarities to plaintiff's script and storybook for TSY. Defendants knowingly and willfully infringed Ms. Davis' copyright works. And that knowingly and willfully goes back to the proven in the law, and you get certain damages. Damages is what reward that you get when you file a lawsuit on somebody and they have to pay you something or do something for you. That's damages. So the knowingly and willfully in certain situations, or sometimes when you can prove that it was knowingly and willfully, you get certain damages for that. I hope I'm explaining this good because I'm trying to explain it in a way that everyone can understand and not in a way like attorney way. Okay, so that, oh, and one thing I wanted to point out, remember that she stated that the defendants told her, oh, Hulu and ABC are looking for Black female-led comedies. And then it comes out that Abbott Elementary is a Black female-led comedy. So remember that as well. Next, defendants knowingly and willfully infringed Ms. Davis' copyrighted work. So that's what we're talking about next. Remember, they're hitting their elements. In addition to the alarming number of character storylines and scenes that are strikingly and substantially similar, if not virtually identical, defendants Abbott Elementary also copied the look and feel of the inner city school, the mockumentary style, unique plot synopsis, set design, and unique characters from the copyrighted work with plaintiff's authorization or consent. It should say without plaintiff's authorization and consent or consent. There's a lot of typos in here. So basically, she's saying they copied my storyline, they copied my scenes, they copied the characters. Well, she said substantially similar, if not vertically identical. Basically, they copied. That's what she's saying, alleging. Several of the scenes in Abbott Elementary involve discrete identical copying from the copyrighted work, any of which independently draws clear conclusions that the Abbott Elementary scenes are directed copies of TSY. Additionally, the main characters are strikingly and substantially similar. From the triad of young teachers whose roles are nearly identical in type. So then she goes into saying literally, in my script, this was the character, in their script, this was the character, and they both have these similarities. So let's go over that. Miss Davis and Miss Teagues, ambitious, young, motivated, naive teachers, both serve at the central character, both look up to and admire the older teachers for advice. Both young women's ambitions are thwarted by the new principal and her schemes. I feel like I read that so weird. I hope y'all got that. Mr. West / Mr. Eddie, young teachers who support the central character and try to guide them. Mr. Ryan and Mr. Hill, young white history teachers, both of them try to be cool in a black school by using rap lingo and black cultural references. So this, to me, it does sound a little bit similar, but I ain't getting into that. I'm staying neutral until I know some more details. And the older main characters who also nearly identical characters. Okay. TSY's principal Lyons, who is incept and hires camera crew in / Abbott Elementary's principal Coleman, who is inept and hires a camera crew to follow her around. Oh, sorry, they were comparing. So TSY's principal Lyons, that was inept and the camera crew was following her around. But then in Abbott Elementary, the same thing happened. TSY's Mrs. Snow, an older experienced teacher that Miss Davis looks up to. And then in Abbott Elementary, they have Barbara Howard, a religious kindergarten teacher whom Miss Teagues look up to. So do y'all think these are coincidences? Or do y'all think this is a coincidence, or do y'all think it's a copy? Coincidence or copy? Let me know in the comments. Additionally, the plots are strikingly and substantially similar. Y'all notice they keep saying strikingly and substantially similar. In the opening episode of TSY, the principal takes Miss Davis' desk for her own. In Abbott Elementary, the principal again usurps the central character by taking her rug. So on one, they took the desk, and the other, they took the rug. Attached here as Exhibit 1 is a copy of the synopsis and first episode breakdown of Plaintiff's script for TSY. So then the rest is just her telling that there's exhibits in here. And tell them what the exhibits are. Exhibits are your proof of what you are saying. So when you file a lawsuit, you have to have proof. You can't just pull stuff out of the sky. So she included her proof, which is, it looks like, was part of the scripts. All right, so that was her claims, right? That's what she's saying. They copied, so she said, it's my work. They had access to my work, and they knowingly and willfully copied my work. Right? So next we're getting into the counts. So what she's suing them for. Plaintiff repeats and realleges the assertions contained in the paragraph above. Plaintiff owns all rights, title, and interest in the plaintiff's U.S. copyright registration. Oh my, I'm getting tongue-tied. Defendants, without permission, license, authorization, or consent from plaintiff, have copied, sold, distributed, advertised, and streamed, and are currently copying, selling, distributing, advertising, and streaming Abbott Elementary, which is strikingly and substantially similar to and based upon TSY. With knowledge of plaintiff's copyright work, defendants have rendered substantial assistance to each other's acts of infringement as described above, and are each thus jointly and severally liable for the infringement. Basically, she's saying everybody that we listed as a defendant helped each other infringe, so they are responsible. Defendants have thereby knowingly infringed. Defendants' infringing acts were committed with knowledge or in reckless disregard of plaintiff's rights under the Copyright Act. So she's saying they knew they were doing it, or they recklessly disregarded, and that's why they did it, okay? The aforementioned acts by defendants have damaged and, if not enjoined, will continue to damage plaintiff and cause irreparable harm for which plaintiff has no adequate remedy at law. So basically, she's saying the damage that they've done is bad, and if they aren't stopped, then basically, wait, I got confused. Yeah, then basically it's going to cause her harm. Okay, plaintiff is thus entitled to preliminary and permanent injunctive relief pursuant to the law, prohibiting defendants from infringing plaintiff's copyrights, including but not limited to an injunction prohibiting defendants from imitating, copying, or making any unauthorized use of TSY in any manner, and from publishing, distributing, selling, marketing, building, or otherwise disposing of any copies of, and from making any derivative works in the form of a second series or otherwise. Manufacturing, producing, distributing, circulating, selling, offering for sale, advertising, promoting, or displaying any copy of or colorable imitation of plaintiff's registered copyright. Okay, y'all, this is a lot. Basically, she's saying they need to stop using all her stuff in all of these ways. Defendants' intentional and unlawful copying has allowed them to receive profits and gains to which they are not entitled. So they're saying they receive money and they're not even entitled to that money because they copy my stuff. Upon information and belief, defendants have made substantial profits and gains from Abbott Elementary that they are not entitled to retain. Plaintiff is entitled to recover from defendants all damages plaintiff has and may later sustain due to defendants' improper conducting, copying of TSY or statutory fees at plaintiff's election in an amount to be proven at trial. The actions of defendants have been willful and deliberate and justify an award of attorney's fees and costs to plaintiff. Y'all, basically, she asking for everything she can get. She's asking for money. She's asking for them to stop doing stuff. Yeah, she's asking for a lot. Which, if they are infringing, rightfully so, she should. So then it says, plaintiff respectfully requests that the court enter judgment that defendants have infringed upon plaintiff's copyrighted works. So she wants this court to say they infringed. Direct defendants to pay plaintiff such damages as the jury determines plaintiff has sustained in consequences of defendants infringing plaintiff's, Direct defendants to pay plaintiff such damages as the jury determines plaintiff has sustained in consequence of defendants infringing plaintiff's copyrights, and to account for all gains, profits, and advantages derived by defendants by their infringement of plaintiff's copyright under, that's the law, or at plaintiff's election, statutory damages under another section of the law. Preliminary and permanently enjoin defendants, their officers, directors, agents, partners, employees, and related companies, and all persons acting for, with, by, through, or under them from copying, streaming, reproducing, distributing, advertising, offering for sale, or selling Abbott Elementary or any other work substantially similar to the copyright work. So basically, she want anybody that got anything to do with Abbott Elementary to stop using it, stop selling it, stop marketing everything. Now, this part is the part that I think is like, whew. Order defendants to deliver up to be impounded during the pendency of this lawsuit. So while the lawsuit is pending, all copies of the copyrighted works in defendant's possession or under defendant's control, and to deliver up for destruction all infringing copies, including but not limited to the immediate ceasing of any Abbott Elementary streaming on any streaming platform. Direct defendants to pay plaintiff costs of this lawsuit and her reasonable attorney's fees allowable to her by the court, and award plaintiff such other and further relief as the court may consider appropriate, and plaintiff requests a jury trial to all matters other than equitable remedies sought herein. So she wants jury trial. But that part, I think, is really important because I believe that Abbott Elementary is supposed to be getting like another season or something, because I saw that this morning on Google because I've been Googling it so much, or yesterday. I think they're getting like another season. And what she's saying is, she's not saying at the end of this lawsuit, she's saying during the pendency of this lawsuit. While this lawsuit is pending, we want you to stop, make them stop. We want this stuff. We want them to give us all of this copyrighted stuff, impound it, take it away, destroy it, whatever. So she wants it to stop immediately, which means that maybe it'll put a halt or a stop to the next season of Abbott Elementary. Maybe, I don't know. But it could cause some issues with the show if this is granted, right? So this is really interesting. This is my first time reading a lawsuit on camera, so I feel like it was kind of weird. I hope it was very clear. But now let's get to the takeaway, okay? What should you entrepreneurs be taking away from this case? The main thing is that you cannot file a lawsuit for copyright infringement unless you have a registered copyright. So the reason she was able to bring this lawsuit is because she had a registered copyright. Had she not had that, you can't file this lawsuit, or you don't have the grounds to file the lawsuit, because you have to. I believe this law changed in like 2019, if I'm not mistaken. But yeah, so if you have creative work, you need to register it. A lot of people do the whole, I have a poor man's copyright, or they say, you know, copyrights are automatic. Yes, copyrights automatically vest in the person that creates the work. However, in order to bring a lawsuit, you have to have a registered copyright. So, excuse me. So the main takeaway for creative entrepreneurs is whenever you create your new content, your new work, your play scripts, your movies, your music, whatever you are doing, you need to register it as a copyright so that when someone infringes upon your copyright, you have that proof of registration and you can file this lawsuit. So that is our takeaway. Always, always, always get a registered copyright, okay? So also, tell me guys, let me know in the comments what you think about this case. Let me know in the comments if it sounds like it is just a coincidence and they just happen to be similar, or if it sounds like they copied. So the theme for this is copy or coincidence, okay? I'm not really gonna say what I think because I'm gonna try to remain neutral in these lawsuits until I get more information. But just let me know what you guys think about this. And let me know if you guys have any questions about copyrights. And I'll see you guys in my next video. These are actually really fun to do. So yeah, bye.